Friends, good morning. Very important video. When we, in the summary trial, admit our fault, such as there are petty offences, just as traffic, and you are fined 20 rupees only, can you be dismissed from service if you are in service? That is the issue which raised in long time back, that in 1996, it was our Honorable Court, Supreme Court, which gave relief to that party. Otherwise, his career in that young stage has been ruined. So we all are thankful to the Honorable Supreme Court that it gave directions and gave relief to the concerned party, as there was a statutory provision. I am talking about Section 294 of the Indian Penal Code. If in summary trial the person is convicted, should be he retained in service or shunted out? This was the issue which is decided in this case. So be settled and listen to my video. Friends, case lies Pavan Kumar versus State of Haryana and others. This is of 1996. Honorable judges of the Honorable Supreme Court who gave relief were respected Honorable Justice M.M. Punchi and K.S. Pari Purnam. Section involved in this case for decision is Section 294. Friends, generally, when the conviction is under moral turpitude, then the employee's job is under danger. Now, whether Section 294 of the Indian Penal Code contains moral turpitude or not. Firstly, this is the issue. Second is for petty offences, what to do. So, before going to the judgment part, I am sharing with you brief facts. Appellant in this case is Pavan Kumar. He was appointed in a class proposed as a field worker on ad hoc basis in the office of the Chief Medical Officer, General Hospital, Bhiwani, State, Haryana. In his terms of appointment, it was made clear that the ad hoc appointment offered was till such a time his character and antecedents were satisfactory, and he would be considered for regular appointment only, keeping in view his character and antecedents. He was required to give a declaration in writing that he had not, on any previous occasion, been dismissed from service and had not been convicted by any court of law. This declaration the appellant presumably furnished. But the bad story is, while he was in service, the appellant came to convicted in a summary trial for offences under Section 294 IPC by the court of Honorable Judge Shri P.L. Khanduja, Chief Judicial Magistrate Bhavani, on his entering upon a plea of guilt. for which he was ordered to pay a fine of rupee 20, which fine he paid, and then it was deposited in the treasury by the chief judicial magistrate. The appellant's appointment in the meantime was kept renewed from time to time. So this situation the Honorable Court has to decide. Now, friends, before giving relief or concluding the judgment, Honorable Supreme Court judges said that we hereby draw attention of the Parliament to step in and perceive the large many cases which, as per law and public policy, are tried summarily, involving thousands and thousands of people throughout the country, appearing before the summary courts and paying small amounts of fine, more often than not as a measure of plea bargaining. Foremost among them being traffic, municipal, and other petty offences under the Indian Penal Code, mostly committed by the young and or the inexperienced. The cruel result of conviction of that kind and a fine or payment of paltry sum on plea bargaining is the end of career, future or present, as the case may be, of that young and or inexperienced person, putting a blast to his life and his dreams. The court further said a beautiful line: life is too precious to be scarred over a petty incident like this. Immediate remedial measures are therefore necessary in raising the tolerance limit with regard to petty offences, especially when tried summarily. Provision need be made that punishment of fine up to a certain limit, say up to rupee 2000 or so, on a summary ordinary conviction shall not be treated as a conviction at all for any purpose, and all the more for entry into and retention in government service. So this can brook no delay whatsoever. As a result of the above discussion, we allow this appeal, set aside the judgment and degree of the High Court as also that of the two courts below, and decree the suit of the appellant as prayed for with causes. That's all, my friends. Enjoy videos. I am putting a lot of time, first reading the judgments, then making brief, then coming before you with folded hands. So please do subscribe. God bless you all. See you again.